they needed somebody to work on specific tech deals where there was diligence going on, and they came across this thing called open source and said, hey, you go figure this out. You've got a computer degree. Okay, great. So I started to delve into corporate attitudes toward open source were maybe not quite fearful, but they were definitely cautious and maybe even a little suspicious of open source, at least in certain sectors. In the area of M&A or mergers and acquisitions, I had to evaluate whether there was the way classes are structured in law school. Unless you have someone who really knows open source, you don't necessarily have someone to teach that class. So I volunteered to teach an adjunct class on open source licensing for students because
Hello, my name is Ildiko.
And I'm Phil.
And this is the My Open Source Experience podcast, where we discuss all the things about the mechanics of open source in business and in communities. Follow the podcast on your favorite platform and check out season 2 episodes with Samson Gotti,
Open source is interesting,
Claire Dillon,
Great collaboration,
Wayne Starr,
Freedom,
Stephen Wally,
Good engineering,
Austin Bryan,
community,
Tom Sadler,
collaboration,
Greg Crow Hartman,
the best way to develop software,
Federico Gonzalez Waite,
limitless,
Amanda Brock,
the future,
Gregory Kurtzer,
collaborative,
Michael Dexter,
freedom,
Ria Farrell Schalnat,
endless learning,
and Kelsey Hightower.
Open source is your opportunity to change the world around you.
Hello, everyone. I'm very excited to be here today with Ria Farrell Schalnat. And this will be one of the last episodes for this season. And we are going back to a topic area where tech and law meets, because Ria has a background in both of these. But before we dive into how tech and law and open source fits all together into someone's life and career journey, Ria, can you please tell us a little bit about yourself, like your background in tech and law, and what do you do currently?
Thanks, Ildiko. I'll start with the now, and then I'll backtrack a little bit to how I got here. Currently, I'm serving as the Principal Engineering Compliance Manager for Hewlett-Packard Enterprise's Open Program Office. This job is the culmination of a lot of my past lives, starting with being a computer programmer to being a lawyer, and even an adjunct professor specializing in intellectual property subjects, including open source. So right now, I feel like I'm living the best of each of those past lives in this role.
I mean, that sounds like you really tapped into all of it. So if I understand it correctly, you started to look into tech and then you ventured over to the area of law. Did I get that right?
Yes, that's perfect. So I started out as a computer science major at the end of the 1980s. Now, for context, this is about when the first version of the GNU GPL was released, but I wasn't aware of that. I was really busy working during undergrad and double majoring, so I didn't get to engage in the school community as much as I might have liked to. I also spent my Sunday afternoons playing Dungeons and Dragons, so maybe that's when I should have been engaging more in computer communities and learned about this stuff, but D&D was fun too. So Linux comes out in 1991, And while I had taken a Unix sysadmin class, I didn't hear about Linux either. So I basically finished a bachelor's of science in computer science and never heard about open source. Then my first real job after graduating was with an insurance company. I was coding in COBOL and C, but being an insurance company, they weren't exactly on the bleeding edge of computer technology. So I enjoyed working there while I was learning, and certainly C and COBOL at that time were well within my wheelhouse. But eventually I got bored with just the rote level of computer programming that was going on, the maintenance level of programming. And it was about this time I started to think about, where did I want my future to go? Did I want to stay in programming? Did I want to go back to school and get an MBA and go the business route, or get a more advanced computer science degree and maybe try to engage in something that way? Somewhere along that discernment, I really resonated with the idea of going to law school. So off I went to law school. Now, I had some wonderful professors at the University of Dayton where I went to school, and I specifically picked that school because they had a really strong intellectual property program at the time. One of my professors was really keyed into software licensing. So that was the area I actually thought I was going to end up focusing on as a career. But he was very much keyed into proprietary software licensing. So I didn't really get any exposure to open source licensing at that time either. To be honest, open source licensing was maybe not quite mainstream yet, so it just didn't figure into my coursework. Fast forward 3 years later, I finished my law degree, focusing on intellectual property, and I still had not encountered any open source there either. Then I went to go work for a law firm. And my first job with this law firm was split between proprietary software licensing and software patents, which had really heated up during the period of time that I was in law school. The United States Patent and Trademark Office had come out with their examination guidelines for computer-related inventions in 1996, right about the time I started law school. And I had this unique background of having experience with computer coding and law that just positioned me really well, right time, right place, to work with clients that had those needs. Suppose at this point it's a good time to mention that while I am technically a lawyer, I am not currently practicing as a lawyer except in a pro bono capacity. And I'm definitely not the lawyer of anybody listening to this podcast. So none of this is legal advice, just general experiences.
During this season, I think we had a couple of conversations. I think it was Stephen Wally who talked about some of the history of copyright on software. And I think Michael Dexter was also mentioning copyright and patents and how they are not always the best match in terms of software development and just the nature of software, how it just keeps continuously evolving. Have you ever encountered any of these challenges as part of your career with law and tech, or you were in a different area of all of that?
Oh, I think he's right on. The tension between law and tech is a very real challenge because technology by its own nature is consistently evolving, but legal frameworks, whether it's legislation or even case law, take years to react to wherever the current state of technology is, or to be decided based on a set of very specific facts that inform whatever that decision is or whatever that holding from that litigation might be. So every time you encounter a new set of facts, you have to shoehorn that prior holding into this new rubric, or you have legislation that assessed the technology at the time, but didn't necessarily anticipate where the technology was going next. So it's always this uncomfortable tension of trying to figure out where to chart your path.
And software patents were really very much defining of that, correct? I mean, as far as not really knowing how to identify an invention in software other than through a process, for example. And so that whole...
And this goes back decades.
Shoehorned, I think, is a good term, right? Because it was just didn't quite fit, but you know, the powers that be made it fit as best they possibly could with what they had to work with.
You know, I think if you could take a time machine and go back to the 1970s when they were first trying to decide how to deal with this new thing called software and how to protect it, if you could go back to that time period, I almost think it would be better to come up with a completely different regime to govern how to interpret and protect software, because you tried to apply copyright and patent and trade secret and come up with some amalgamation of these pre-existing frameworks that none of them quite captured this new technology very easily. You've created a system that now has 50 years worth of case law and legislation that layers on top of itself to try and solve problems in the realm of protecting this stuff that never really was designed to do that in the first place.
Early in your law career, you were focusing on the area of mergers and acquisitions. Do I remember that correctly from our prep call?
Yes, that's exactly right. So that was how I first became acquainted with open source. As I mentioned, I started out in law firms and I was splitting my time and my caseload between software licensing clients and patent clients who wanted to patent software inventions. But that wasn't quite enough to fill my entire docket. So I got involved with the mergers and acquisitions team. They needed somebody to work on specific tech deals where there was diligence going on, and they came across this thing called open source and said, hey, you go figure this out. You've got a computer degree. Okay, great. So I started to delve into what these open source licenses meant and how to interpret them. And here's where open source sits in this really interesting place. It is a merger of community, technology, and those legal underpinnings that we've already talked about: trade secret, patents, copyrights, and even trademark law comes into play with open source. So it's a little bit like learning a foreign language. You can pick up a book written in another language and you could translate it word for word, and you would be technically correct. You would have that translation, but you would miss a world of the nuance associated with that book written in that other language because you don't know the language. Open source license interpretation, I think, is very similar to that because you can look at the language of the license itself, but if you don't consider the overall project that is involved, the use case that you're applying it to, the history of either the project or even the license development, the sensitivities of the community that engage with either or both of those things, and any legal actions that may have occurred in the past, even if they didn't ultimately lead to a decision by a court of law, you are not going to understand what that license really means or how to apply it or advise your client ultimately. One example of this, the BusyBox lawsuits. Those were settled. So you didn't have a decision by a court of law, but they're often cited as one of the litigations that gives heft to the enforcement of copyleft licensing.
I never even thought of that. Like the difference between settlement versus having that court ruling.
So as an attorney for a law firm, my job was to interpret the law for my clients and also to understand their point of view and advocate on behalf of them and figure out how can I make these two things meet in the middle, what their goals and objectives are versus whatever the legal situation is that I was evaluating. In the early 2000s, corporate attitudes toward open source were maybe not quite fearful, but they were definitely cautious and maybe even a little suspicious of open source, at least in certain sectors. In the area of M&A or mergers and acquisitions, I had to evaluate whether there was something that might negate the value of a particular deal that a client wanted to engage in. The business has generally already decided that this makes good business sense by the time you've hired a law firm to do the M&A deal. They've decided this makes a lot of sense for our business, for our objectives. So my job was effectively to determine whether or not there was something that would negate the value of that deal or potentially raise a flag to say, hey, put the brakes on this. You might want to reconsider or do something different.
In terms of the your work with mergers and acquisitions and evaluating all the, let's say, I don't know, circumstances, whether or not that deal end to end is what the client really wants to go through with. Did you feel that open source introduced like a lot of added complexity compared to just the licensing and IP and all the other areas that your work was covering already?
Well, it definitely was a different thing to consider. It was a different rubric that people weren't always used to. And one of the things that I would look at would be whether or not there was some issue related to open source, perhaps an open source obligation that had not been fulfilled, or maybe even more seriously, a cease and desist letter that existed in the data rooms that you create as part of doing an M&A due diligence. Either way, that presents a potential risk because, again, open source is based on intellectual property law and sometimes contract law theories, and both of those need to be taken seriously because they could potentially result in litigation, which is expensive for companies. Additionally, the use of trademarks associated with certain open source projects. Those aren't typically granted in open source licensing, so that could present intellectual property issues. If a particular deal was based on the value of the software that the company wanted to acquire, that they felt that was market differentiating technology that they wanted to have as part of their portfolio, but it turned out that all of that was based on open source and just available on the open, and they could just simply consume it off of GitHub or wherever, then maybe it's not worth the money that they were contemplating paying for that deal if it turns out that the software that they're trying to, or the solution stack that they're trying to get was based on open source. And they'd need to know about that too. So some of the things that you might consider doing in an M&A cycle, one, if there's a risk presented, you might decide that the risk is negligible or that it's something that's easily remediated, that you could just deal with it after the deal has closed, and you might go forward on that set of train tracks. You might look at it and say, hey, we still want this deal, but this is really impactful, what we've discovered in the diligence due to the open source. Maybe it's not worth quite as much money, so there might be a counteroffer involved based on that issue. You might decide to nix the deal entirely, because maybe there's something about the lack of compliance in a company that just seems too difficult to take on. And the company that's doing the acquisition may not want the PR or the litigation or any of the other issues that might come up with open source. And the final thing that you might try to do is acquire some closing conditions. You might say, well, this is a big issue. We don't want to deal with it ourselves, but we could make the deal contingent on the entity that we're acquiring fixing it before we close this deal. Sort of like when you buy a house. If the air conditioner is broken, you might say, fix the air conditioner and then we'll buy the house. They might ask that you fix your open source compliance issues and then the deal can go through. So those are just some of the pathways that might come up in a typical M&A. So that's where I would focus in terms of evaluating the open source issues involved with any software that was part of the acquisition.
That sounds way too complex for me, who started out as a software developer. Just out of curiosity, you mentioned that you were learning about open source licenses, and you also talked about how open source is not just the license, but the technology, the community, and all those things. So at that time, when you were learning about open source and doing all these evaluations for the mergers and acquisitions team and all the other parts of your work, were you able to get into that community side of open source at all, or were you more focused on the licenses at the beginning?
Well, definitely my first experience was just even encountering the licenses, but it was wanting to learn more about how these get interpreted. And especially at the time that I was doing M&A, there was virtually no case law in the open source realm. You were relying on case law that had other theories attached to it, like copyright or patent law, to figure out what the risk profile really was. I don't think we had a actual decision in open source until around 2008 with the Jacobson versus Katzer decision. That was the first case holding that said, hey, this is an open source license and it is indeed enforceable. Up until that point, some people weren't even sure whether or not this actually would work in a court of law. So I just wanted to get to know more about how this ecosystem worked. And I started by attending continuing legal education seminars and other webinars and task groups that were focused on open source. And that's where I got to start learning about the community behind open source. So I remember meeting with Karen Copenhaver at one of these CLEs and Dave Marr, who had both been speakers at this particular CLE. And both of them were very encouraging of my interest in open source. In fact, Karen had pulled me aside to say, there aren't enough women in this area. Keep up with it. So that was very exciting for me to have someone who is sitting up there on a CLE panel saying, do this, keep going, this is important. And I decided at that point, as opposed to just me going to CLEs and learning on my own, I needed to educate more of the legal community within Cincinnati. So I was involved with an intellectual property bar association that held seminars and conferences. And I proposed that we have an open source conference in Cincinnati. And I reached out to Dave to say, would you be willing to come to Cincinnati and talk about open source for me? He was really gracious and wonderful about doing this. So he was the corporate view on open source. And then I also got connected, and honestly, I don't remember how I got connected to him, but Bruce Perrins, who is identified very strongly with the Debian project, he said he would come so long as I could dovetail the conference with Hamvention, which was happening in May in Dayton, Ohio, which was oh, if we can get Bruce Perens at our conference, that's amazing. Yes, we will design the entire conference around Hamvention so that we can get Bruce Perens to show up and talk to us about open source. And then the final person that we had, a couple other people speaking, of course, but the other really keynote speaker that we had was Bradley Kuhn came because one of the people on the planning committee for this conference was a professor at the University of Cincinnati who had Bradley Kuhn as a graduate student. At this time, Bradley was working for, I think it was the Software Freedom Law Center, and now he's with the Software Freedom Conservancy. But he agreed to come to the conference, to come back to Cincinnati since he had some roots there. And so we had a really incredible lineup. We had corporate with Dave Marr, Bruce Perens for the Debian project, and we had Bradley Kuhn from the litigation and enforcement perspective being with the Law Center. This was amazing to get this in Cincinnati, and this was around maybe 2007, 2008 that we had this conference. Planning this event was probably my first real lesson in the power of community, because all of these people, from Dave Marr, who had just met me in passing at a CLE event, to these giants of open source like Bruce Perens and Bradley Kuhn, none of them knew me as anyone in the open source community, but they were all willing to come and share their knowledge. So it's kind of like the saying goes, it takes a village, and the connections of the people on this planning committee, we all managed to make it happen.
It sounds like it was such an amazing event and provided a lot of information and different viewpoints into open source from all those pillars that you were talking about, like the law, the technology, the community, and all those things. Do you remember what impact the conference had to people who were attending it?
Well, we had over 100 people come to this conference. So that was a testament to how people were hungry for this information and really wanted to hear from the people who were intimately engaged with open source and understand what the issues were. Eventually, this conference ended up morphing into a larger tech conference that was run by Northern Kentucky University, and they had a full day conference related to all sorts of computer-related issues and technologies and hackathons, workshops, languages, etc. But then they grafted in a legal track to their conference, and I think it's still going on today.
Wow.
Oh, that's amazing. I love to hear that. I'm also curious, like at one point you mentioned that I think with the mergers and acquisitions team, someone told you to just go and dig into this whole open source thing because you have some tech background. I don't know if you were still with that team and company at the time when you organized the conference, but if you were, I wonder if you took any of your colleagues to the conference, or what other ways did you use once you learned about open source to help them understand what it was?
Oh, absolutely. I mean, there were people from my own law firm who came, but I think even more broadly is that I wanted it to be a rising tide raises all ships sort of perspective. I just wanted to increase the acumen of open source across all of the law firms in Cincinnati that I felt needed to be part of understanding this so they can advise their own clients. And it was a really interesting thing being part of this intellectual property bar association because it was almost entirely populated with law firms who were ordinarily competitive to each other, competitive with regard to getting clients, but in this space of learning, we all worked together to try to help each other understand legal risks and legal issues so that we could be better lawyers. And open source fit really neatly into that entire rubric.
So you were kind of, through that collaboration, you were sort of doing open source while still learning about open source.
Yes, I guess so.
That career journey that Ria you had with this intersection and fusion between tech and law. So eventually you got a job at Amazon, which I would imagine was a big change in your life, personal career, all that. I think it even included you moving states within the United States. So what influenced that career move?
Yes, it brought me to Seattle. So now we're next door neighbors. So I had moved out of law firms into being a general counsel for a tech company in Cincinnati. It was an amazing experience for me because I got to really broaden my legal chops beyond intellectual property into all sorts of areas. Everything from litigation to corporate governance to immigration. And I was working in areas that I had never dreamed I would work in at that company. But over the course of the years that I was there wasn't as much opportunity to do work in the open source area. And I was even finding it challenging just because of the other duties that I had at this company to even find time for intellectual property in general. I was finding that I started out where I was doing a fair bit of intellectual property for them, but as time went on and other needs arose, I had to outsource the IP work and basically take on a more managerial aspect to that as opposed to the day-to-day doing of it. So after about 4 years, I really missed being part of the intellectual property world. And so I decided that I wanted to look for an opportunity that would let me either get back into patents or get back into open source in some way. And this is where I got connected to Julie Mowers at Amazon through Dave Marr. You remember he was the one who encouraged me initially to get involved in open source and came to my conference in Cincinnati, and we stayed in touch over the years. And he said, "Hey, I've heard Amazon is looking for someone who can do some open source. Are you interested?" And I said, "Absolutely." So had the interview, and the job was pretty much perfect for that stage in my life because it was going to be working as a mini GC or a mini general counsel for a lot of different business units within the products team of AWS. One of those mini units was working with their OSPO. So I was going to get to do open source work, but also leverage some of the experience I had from working in the company I had been in to use those talents and experience to help the other business units. And I also added into the mix working with their M&A team, doing what I used to do with the law firms in terms of open source diligence. So really a perfect merger for where I was at that stage in my career.
Did you, like, as you moved to Amazon, which is like a large company, a lot of people, I assume processes and all those things. So how do you remember this period? Like, did it feel still like a steeper learning curve into like how a large tech company is approaching this intersection of tech and open source? Or did you feel that all the things that you learned, you were just able to put them in practice on a day-to-day basis?
I think there was a lot of give and take both ways. So there were specific things that I was bringing to the table where I could improve processes or contribute my knowledge. But Amazon being what it is, it was also drinking from the fire hose, and just the sheer diversity of open source issues that I got to deal with because of all the different product lines, whether it was on the AWS side or the broader Amazon side. That was an amazing experience to be able to play with all of these different technologies and interpret how open source licensing applied to them, within them, open source projects that Amazon itself was launching. All of these were really incredible working experiences. But the best part really was working directly with their OSPO, because Amazon being who they are, they had just an amazing group of people in their OSPO who had depth and breadth of open source experience, and I just drank it all in.
What did you find the most interesting at that time? I assume you really got to work with open source on a daily basis there. Like, there was no further desire that you want more than what you already got in terms of exposure to it.
I think one of the key areas of exposure that I gained working with their OSPO was to start getting connected with the broader communities that were involved in open source. Up until this point, and while, yes, I had organized that conference in Cincinnati, I had not really become engaged in projects or foundations up until that date. And to be honest, I look back on it now, and I'm a little perplexed as to how I did not get involved in some of these things earlier, given that I was really interested in open source once I discovered what it was. I don't know how I wasn't aware of certain open source specific conferences or things like the Linux Foundation. That just kind of blows my mind right now. But I think it probably was some combination of the fact that working either as a GC or a lawyer trying to make billable hour goals at the same time that I had small children, that affected my priorities and what free time I had available to be able to engage. So I think it was maybe more of just not the right time in my life to expand where I was putting my energy because I had other priorities.
You mentioned that during your time at Amazon, like, it sounded like one of the best things or the best experiences was this exposure to community and events and more of the open source space. And then from Amazon, you went over to HPE and joined their OSPO, or rather they call it, I think, Open Program Office. So was this kind of a coincidence that you got a job at the Open Program Office, or was this something that you were specifically looking for to be able to now not just work with the OSPO/OPPO, or but rather be an integral part of it?
It was definitely an objective. So as I mentioned, the open source program office at Amazon was fantastic, and I loved working with them. So I was starting to look for how can I do more open work. Now, they didn't have a rec available within their own OSPO to put me into that place. And at the same time, the other legal jobs that I had as being part of the products team were crowding out some of the time I could spend on open source. So I was looking for another opportunity. At this time, Mark Atwood, who had formerly worked at HPE, said, "Hey, I heard my former boss, Paul Holland, is looking for a new open source compliance manager. Would you be interested in this?" And Phil, you worked with Paul, right?
and Mark.
Okay, great. So you work with both of them. So Mark said, why don't I introduce you to Paul and see if it works out? And it did. And so the last 3.5 years are history now.
I mean, again, the power of community and knowing people, I think it's just continuously underestimated, and very often the world turns out to be a small place in terms of, oh, I know that person too. And even within global communities, people move around, and when you meet someone from one place, then you will meet them in a different community, different area. And it's just nice to have these sometimes friendships that just last forever. So as you went over to HPE, in your experience, how did your day-to-day change? What was different between the companies and the job that you were doing?
Good question. So as I transitioned from going from law, being part of a legal department, to now moving over to the business side of things. And at the time I joined HPE, we were still an OSPO, so it was an open source program office at that time. It's the first time in my career that I could say 100% of my bandwidth was dedicated to open source issues. Up until that point, open source was always something that I engaged in. Sometimes it would consume 100% of my bandwidth, depending on what project I was working on or a due diligence that was in effect at the time. But it was never year to year 100% of what I was doing. I was always layering in either other general lawyer duties or intellectual property or software licensing tasks into the mix. So now I get to work 100% on open source. And as part of that day job, I am now finding the ability to engage more and more in communities that I didn't really have the bandwidth for when I was at Amazon, and that I was only just starting to get a taste of through exposure to their OSPO. Now I could see where the value was in integrating into these communities, because it enables me to make those connections for other people.
It sounds like that it is encouraged as part of your job to not just know and learn about open source technology and projects and communities, but also participate in the ones that are relevant for the company and the area that you're working on at the moment.
I think not just encouraged, but necessary. Absolutely necessary.
What makes you say it's absolutely necessary?
Well, just as an example, we were talking about the SBOMs before. And there's multiple layers of intersecting communities that deal with SBOMs. And this is one area where we as a company have had to adjust processes and evaluations, et cetera, to facilitate the requirements that have been put in place by the government due to SBOMs. Until 4 years ago, until this executive order, I don't know how many companies were actually exchanging SBOM documents. I know that Kate Stewart from the Linux Foundation had been an advocate for SBOMs for at least a decade, but often you need that weight of either a case decision, a piece of legislation, or an executive order before you really engage in having the infrastructure and the processes and everything set up in the pipeline to make it happen. So with SBOMs, that very heavily involves SPDX, which is a project under the Linux Foundation, and their specification, as well as the legal group within the SPDX org that assigns the IDs to the licenses. So when I first got involved with the SPDX group, and their legal group specifically. I had a bit of an evolution for my thinking on how SPDX should be treated, because I joined it thinking that the matching guidelines that they had could be a way of discerning whether or not we should let a new open source license into the mix and assign an ID to it, and that we might say, let's try to curtail the number of licenses that are out there or that have IDs, so that, maybe we could winnow it down to more consistent or fewer licenses, because that would certainly be more scalable to assess as a legal department. So I kind of came from it from that perspective of having been in legal and evaluating all these different licenses that are variations on a theme. And I was sort of the grumpy person on the call who would look at the latest BSD variant and say, really, do we have to assign an ID to this because it's got 3 words that are different from BSD 3? They just don't fit the matching guidelines. So do we really need another BSD variant in the SPDX pantheon? The SBOM movement completely flipped my attitude on its head. So I've done a 180 now, because having this machine readable mechanism to be able to ingest a document with the components that make up a software stack and the licensing that is part of it, if you include the licenses, and I've pushed really hard in some of the CISA community groups to include licensing in the SBOMs. By doing that, you can better scale the assessment and the application of policies and actually do a more complete job of assessing risk. So all of these pieces just fit together really, really nicely. And now I'm very much in favor of attaching an ID to every open source license that we come across, because it's going to ultimately make it easier to do the job. But all the pieces had to fall in place first. So when I first got involved in this organization, I had a completely different attitude than I do today. And a lot of that has changed because of the maturity of SBOMs in industry.
And the tooling around it. Yeah, exactly.
Yeah. And that's why I say it's necessary, because if I had not been involved in either the SPDX legal group or the CISA community groups, which are not strictly open source per se, but they're very strongly attached to the open source world. If I hadn't been involved in those community groups, I would not have been able to advocate for positions that can potentially make all of our work more scalable and more machine processable, I guess. That is a real advantage that then I bring back to HPE, because if we have these things in place, then once we have our SBOM, we can apply policies to it to give people an earlier heads up to say, hey, this works, this doesn't work, this has a warning, and that will let people make smarter choices in the long run.
Before we depart, Ria, can you tell us something about yourself that has nothing to do with tech, law, and open source? Some kind of a hobby or fun fact?
So I am a really huge J.R.R. Tolkien fan. We took a family vacation to New Zealand about a year and a half ago, and I got to spend the evening in Hobbiton at the Green Dragon Inn. I highly recommend it to anybody who is a Tolkien fan out there. We took the whole family. They were all thrilled. We've raised our kids right. They have a sincere admiration for that author. And my fandom goes way back to the days before the movies. When I was in high school, I played Gollum in my school's production of The Hobbit. So that was my one brush with community theater fame, was when I got to be a pre-Andy Serkis.
That is so cool. I love that. It's always nice when you're able to dive into these interests. Like there's a writer and there's a book, but then there was a movie, there was a set and location where they filmed the movie, and there are the school activities that are resembling the work that they did. So it's like you get connected to them in a way, and like there are also communities around movies and fiction and things. So cool.
Maybe that's the bottom line, is people just want to connect, whether it's open source or it's some other fandom that you're engaged in. People, I think, have a genuine need to connect with the things that they love. And that's what makes it so vibrant and interesting.
And with that, that's all, folks. That was our episode for today. We want to hear from you. Please leave comments under the episodes that you watched. Share your feedback and share your experiences to continue the conversation. And let us know what topics you would like to hear next. We already have a lot of great content lined up for Season 2. We will talk about inner source, or in other words, why and how companies are using open source methodologies internally. We will talk about why and how governments are using open source and touch on upcoming legislations such as the Cyber Resiliency Act in Europe. We will also discuss how to create open source projects and communities that last for decades. Stay tuned because the next episode is just around the corner.
Wouldn't you wish there was a silver budget, but no, silver budget as well. Silver budget that is a
that's
silver
what you
bullet.
need is a silver. Exactly.
That's it. And to be fair, some people.
So I bought some bidets. This should have been a very simple project. This should be simple. What bidet do you want? You install the bidet and you sit down and you enjoy the bidet. That's it, simple. But I bought the best bidet. You know how engineers go. Nothing simple.
But we just had a good time just talking and whatnot. And by the end of it, he figured out I played pretty quick. So by the end of it, he actually made me play with him. And so I played music with Kix Brooks. That was fun.
Way cool. That's a great story.
He is waiting for me to finish this podcast so that, I don't know if you